Okay.
But that's the reason why I couldn't get my license reinstated. It was never suspended or revoked. It was just expired.
Okay. Anything else that you want me to know?
No, that's just it. Well, because of the year 2022, the tornado, we didn't get our mail for like 9-10 months because we were living in hotels. So it's not like I wasn't trying to appear. I just didn't know when. It was pretty hectic. It's been pretty hectic. But yeah, I'm done, sir.
Is that it?
Yeah, yes, sir.
Okay. All right. In this particular case, the charges are, while there are felony offenses attached to the charge, the charges are much less serious and much less in number than the previous case. This is a possession, the most serious one is a possession of methamphetamine charge rather than manufacturing or delivering. And the second count, while as a high court misdemeanor, is maintaining a drug house, which is a much less serious controlled substance offense. And then count 3 is simply a misdemeanor. So for those reasons, in addition to the ones I previously indicated on the record in the previous case, I'm simply going to set this at $5,000 cash surety or 10%, so you'd be able to post $500 and be released on that one. Once, or if you are released, again, the same conditions will apply, that you personally appear for any scheduled court date, that you abide by any judgment of the court, that you not leave the state of Michigan without prior permission of the court, that you not commit any crime while released, that you immediately notify the court in writing of any change of address or telephone number, that you not use any alcohol or illegal controlled substances, and that you participate in a substance abuse testing or monitoring program through community corrections. I am again going to say...
The proceedings begin with the defendant explaining why his license was not reinstated, clarifying that it was never suspended or revoked, but simply expired. He describes how a major tornado event disrupted life, forcing him and others into temporary hotel living, which caused months of lost mail delivery. This disruption led to miscommunications and administrative confusion. The defendant insists he was not avoiding the system, but was affected by real-life circumstances. The court listens as the foundation of the case is set, highlighting personal hardship before legal arguments move forward.
No possession of a firearm or other dangerous weapon, and that you contact community corrections at the number that's to be given to you at the jail within 24 hours of your release, so that you can be monitored while you're on probation, or while you're on bond. Excuse me. Do you have any questions about the bond in this case, sir?
No, John.
All right, Mr. Truce, any questions?
No, Your Honor.
Mr. Fortier, anything else?
No, Your Honor. Thank you.
All right. I'm going to make myself a note, Mr. Weber, as to your medical issues, that you can bring those back up to me through your attorney in the future. So just give me a minute to make a note so I remember that.
Will I get a chance to talk to the attorney today so I can tell him what to tell my wife to get to you in case for that thing tomorrow?
You can ask Mr. Truce to assist you with that. I don't know who that next attorney is going to be yet, so I don't know who to contact about that, but I believe Mr. Truce could probably pass on a message to whoever that's going to be.
That would be great, because since it's tomorrow, that's the only reason I'm asking.
Yep. So I'll ask Mr. Truce to contact Mr. Gilo's office and see if they can hurry up the appointment process and have that attorney contact you as soon as possible. But that's about all I can do right now. And once I've made my notes here, we're going to address the bench warrant arraignment. So just give me just a minute and we'll be moving on to that. All right. We now address the 7 bench warrant arraignments that I previously identified on the record. I'm going to tell you what all of the dates and times are, just so that you're aware of what those things were, and then I'll tell you what your rights are as to all of those cases, and then we'll decide what to do about all of them. So just give me a minute to kind of wade through these so that you know exactly what you're looking at here. In file 40885, 22-40885-.
The judge outlines a bond decision. setting it at $5,000 cash or 10%, allowing release for $500 under conditions. Strict rules are imposed, including mandatory court appearances, no travel outside Michigan without permission, no new criminal activity, and immediate address reporting. The defendant is also prohibited from using alcohol or illegal substances and must participate in monitoring through community corrections. Additional restrictions include no possession of weapons. The court emphasizes compliance and supervision, reinforcing that release is conditional and closely monitored under legal authority and structured behavioral expectations.
ST, there is a bench warrant that was drafted, actually a motion or order to show cause. It says that you failed to appear on 8/1 of 22 for a notice of arraignment on a charge of driving with license suspended.
Oh, 8/1/22, okay.
August 1st of 22. The next case, file 23.
Can I ask when these bench warrants were given for this now?
And they were given at different times. So this one was done on 8/1 of 22.
No. Why am I getting a bench warrant now, though? What date did I miss? That's what I'm asking.
You failed to appear on August 1st of 22, and a bench warrant was issued that same date. It's been outstanding since then.
I thought we took care of that last time. We went through all this. That's what I'm saying. The prosecutor told me that he gave me a plea.
July 8th of this year was the most recent bench warrant issued.
Well, let me find it here.
Yeah, that's what I'm talking about. I never got that court date. I talked to the prosecutor about it.
The bench warrant itself would be in the brown folder.
I don't like that.
Because I gave my number, he told me, well, he asked for my number and said he'll call me because remember when I showed up and you said you're not supposed to be here yet?
Mr. Weber, I see about 50 people a day, multiple days a week. So no, I don't remember that, sir. I apologize, but I know it might have been fun for you or memorable to you, but it was not to me.
Right.
Okay?
Yeah.
All right. I'm been directed to a different part of the file by the court staff, and I do see a newer bench warrant, which indicates that you failed to appear for a jury status conference on July 3rd of 20.
The hearing shifts as multiple bench warrants are reviewed, many tied to alleged failures to appear dating back to August 2022 and more recent dates in 2025. The defendant questions why warrants are being addressed now, claiming lack of awareness about certain court dates. He argues communication issues and misunderstanding, stating he never received proper notice for some hearings. The judge clarifies that warrants have been active since missed appearances occurred, emphasizing the seriousness of repeated non-attendance and the accumulation of unresolved court obligations over time.
Of 2025. So that is the allegation against you at this point.
Yeah, I was not aware of the date. That's all, Your Honor.
I appreciate you bringing that to my attention, so thank you very much for doing that.
And Judge, I just want to bring this up because I think there might be a little confusion on Mr. Weber's behalf. The last time I talked to him, it was actually me personally that he spoke to. It was on May 21st of 2025. My job is not to provide him with the court dates. He should have called district court. I know when we discussed it, I had brought up the fact that he had mixed up court dates, but the onus is not on me to provide him with his court dates. So I don't know where the idea that I told him that I would call him back with his court date came from.
Because that's what he said.
But that's not what happened. So.
Well, and he's also previously given me a statement that he couldn't get his mail, so that he didn't know when to appear for court, and he could have called the court no matter where he was living at and found out that too. So I understand all that, Mr. Portier, but I'm happy to let you put that on the record. So, all right. The next, I understand what you're saying, sir, and I just want to let you know that just because it's said in court doesn't necessarily mean that everybody is that the only thing. It's all right. Next case is.
I'm supposed to get let through the mail too.
Okay, Mr. Weber. Here's what we're going to do. I'm going to give you a chance to tell me anything that you want to tell me in just a minute. Right now, I simply need to tell you what these dates are and what the bench warrant arrangements are. Then I'm going to tell you what your rights are, and then I'll give you a chance to tell me whatever you want me to know. So you just got to be patient with me. All right. So in file 23-41430, the bench warrant is for failure to appear for a jury status conference on July 3rd of 2025. So it looks like there's a bunch of recent court dates set on a lot of these files, and you failed to appear for that. So that's number 2, the second file that we've dealt with here. Third file is 23-41806-ST. That also alleges a failure to appear.
The discussion intensifies as the defendant insists he was misinformed or not properly notified about court dates. The prosecution responds that responsibility lies with the defendant to confirm dates through the court system, not solely rely on informal communication. A prior interaction is referenced where the defendant allegedly misunderstood scheduling details. The judge notes high case volume and clarifies limited personal recall of prior conversations. Tension rises but remains controlled, as both sides present conflicting accounts of communication breakdowns and procedural expectations within the legal process.
For a jury status conference on July 3rd of 2025. Next file is file 23-41671-ST. That also alleges a failure to appear for a jury status conference on July 3rd of 2025. Next file is 23-41545-ST. That alleges a failure to appear for a jury status conference on July 3rd of 2025. Next file is file 22-41083-ST. That also alleges a failure to appear for a jury status conference on July 3rd of 2025. Finally, we have file 17-34550-ST. That also alleges, failure to appear for a jury status conference on July 3rd of 2025. As to each of these bench warrant arraignment files, you have the right to have a contested hearing in front of me as a judge. You do not have the right to have a trial a hearing in front of a jury, as these are bench warrants, failure to appear in front of the court, not an extra criminal case. You do, however, have the right to be represented by counsel. You have the right to see, hear, and question all the witnesses against you at that hearing. You'd have the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. You could testify or you could remain silent, and the silence could not be used against you. You'd have the right to testify yourself or to remain silent. You'd also have the right to be presumed innocent until proven guilty. The burden of proof at a bench warrant arraignment hearing would be by a preponderance of the evidence. It would not be beyond a reasonable doubt, as again, this is not a new criminal case. And finally, you'd have the right to appeal. You understand all those rights, sir?
This is for the bench warrant part, right?
This is for all of the bench warrant cases, yes.
But it's not the case itself, right?
Not the case itself, it's just the bench warrant. That is correct.
Okay. Yes, I understand.
Yeah. All right. As to each of these cases, I'm going to appoint the same attorney that you got in the felony cases, because it seems to make good sense to have you have an attorney represent you in all of those cases. So rather than set a hearing right now, I'm simply going to continue those cases until there's an appearance by counsel in the felony cases.
The court formally explains the defendant's rights regarding the bench warrant hearings. He is informed of his right to a contested hearing before a judge, legal representation, the ability to present evidence and witnesses, and the right to remain silent without self-incrimination. The burden of proof is clarified as preponderance of evidence rather than beyond reasonable doubt, since these are not new criminal charges. The defendant confirms understanding. The judge ensures procedural fairness, emphasizing constitutional protections despite the administrative nature of the bench warrant proceedings.
And then we'll address all these bench warrant cases at the same time. And if you're able to reach a resolution of all these cases, you may be able to talk, or your attorney may be able to talk to the prosecutor about it. So I'm not going to go any further than setting an attorney for you on these cases. Mr. Truce, do you have any other requests for me on these cases? I'm simply going to set a $500 PR bond in each of them. There's no reason for me to do anything different given the felony level of bonds we've already set.
Thank you, Your Honor. I actually was going to suggest the same to the court, so no argument there. I think a PR bond is appropriate. I do think that Mr. Gilo's office must be listening into the hearing somehow, because they messaged me and identified to me that Mr. Dick will be appointed to Mr. Weber. So I give that information both for the court and for Mr. Weber's benefit. I've already contacted him and provided him with your wife's phone number. So
I have nothing to write anything down with.
They've already sent that information about your wife to Mr. Dick, though, so he's already aware of that. If he needs any additional information, he can contact you at the jail. That's basically what Mr. Truce said. All right. Mr. Fortier, is there anything else that you would ask the court to do on these bench warrant cases?
No, Your Honor.
Mr. Truce, is there anything else that you want me to do on these bench warrant cases?
no, Your Honor.
All right. And Mr. Weber, is there anything else that you want me to do on these bench warrant cases?
I just want to tell the prosecutor I wasn't throwing him under the bus. I was just relaying the last time that we had talked.
That's fine. That's fine. Thank you very much.
That way.
I appreciate the good attitudes you've had throughout this hearing, sir. So, all right, that'll be all for today. Thank you very much. Your attorney will be contacting you shortly. All right.
Thank you.
Must we have? If you could ask the jail to take you back and then bring in Mr. Garinger.
I banged the door. There's nobody.
Yep.
The judge appoints the same attorney from felony cases to represent the defendant across all bench warrant matters, instead of immediate hearings. The cases are adjourned until legal counsel is fully involved, allowing unified handling of all charges. A $500 personal recognizance bond is set for each case. Attorneys confirm agreement, and coordination between court staff and defense counsel is noted. The hearing concludes with instructions for legal follow-up, communication with family, and continuation proceedings, leaving resolution to future court dates under structured legal representation.